Hello, and a very warm welcome to everyone attending today. My name is Philip Liddell, and I'm the chairman here at Burkitt Long. I'm delighted to be able to introduce this Wednesday webinar. As you may know, Burkitt Long are offering regular webinars on a wide range of legal topics. Future subjects will include some guidance on the duties and responsibilities of trustees, and then a session in December on how Burkitt Long's commitment to people, environment and communities can benefit our clients. If you're interested in any of our webinars, please sign up at www.burkittlong.co.uk/events. This afternoon's seminar is on statutory wills, what they are, when you need them and how they operate, and is going to be delivered by Kay Baker, a senior associate at Burkitt Long. So without further ado, I will hand over to Kay.
Thank you, Philip. As Philip said, my name is Kay Baker and I'm a senior associate solicitor at Burkitt Long in our Court of Protection and Inheritance Disputes team. We deal with all disputes relating to wills, trusts and powers of attorney, as well as dealing with contested and uncontested Court of Protection applications. In this webinar, I'm going to talk about statutory wills, which is a type of application to the Court of Protection. Now, if we can look at our agenda for today, we're going to talk about what a statutory will actually is and when one might be needed. We're then going to look at the mental capacity needed to make a will. We'll look at the procedure for making a statutory will and also the factors the court will take into account. There will then be an opportunity for you to ask questions, which I'll try to answer, but please note that I cannot give specific legal advice during the webinar. As I say, I will be giving general information only in this webinar and you should seek specialist legal advice on your own situation. So, what is a statutory will? A statutory will is a will written on behalf of someone who lacks the mental capacity to make one themselves. It must be approved by the Court of Protection. The statutory power lies within the Mental Capacity Act 2005. The Court of Protection actually has the authority to make many types of decision for an individual who lacks the capacity to make those decisions for himself. The Court of Protection can appoint someone as a deputy. A deputy is a bit like an attorney appointed under a lasting power of attorney, and you can be appointed as someone's deputy for property and financial affairs, or their deputy for health and welfare decisions. Broadly speaking, it gives you general authority to make decisions in those areas. However, for the avoidance of doubt, neither a power of attorney or a deputyship order authorises you to make a will for someone else. The Court of Protection can make specific decisions about someone's finances, such as whether to sell their house or whether to make gifts. It can also make specific decisions about their health and welfare, such as whether a person should receive medical treatment, where they live, or even smaller issues like who's allowed to visit them. I dealt with a very difficult case where a lady from Eastern Europe had a catastrophic road accident whilst living in this country. The Court of Protection had to decide whether she should remain living here, where medical treatment was more specialised, or return home to be closer to her family. So you can see they are difficult decisions, but also a huge range of decisions that the Court of Protection can be asked to make. However, in this webinar, I'm only going to focus on statutory wills. So why make a statutory will? Well, there are lots of reasons. It may be the case that the person who lacks capacity does not have a will and the intestacy provisions are not appropriate. The intestacy provisions are the rules that govern who will receive someone's estate where there is no will. They are tweaked from time to time to modernise them slightly, but they're often inappropriate for a person's individual situation, particularly now with lots of us living in less traditional households. For example, if John has a long-term partner, but is unmarried, that partner will receive nothing under the intestacy rules on John's death. If John lacks capacity, it may be necessary to apply for a statutory will that is more appropriate to his situation. If you have a family member who lacks capacity and doesn't have a will, I strongly recommend you check the intestacy rules are appropriate for the distribution of their estate on their death. For example, if you're married with children, it is not the case that your whole estate will pass to your spouse on intestacy. Equally, it may be the case that the person does have a will, but it's no longer appropriate. This could be due to a change in relationships, such as more children being born in a family after the will's been written, a new partner, or a family member's death. Or it could be down to a change in assets. If I leave a house to somebody, a specific house, and then sell that house, then the will may well be very much out of date. Another example would be if a will left a person's house to certain beneficiaries and their residuary estate to others, and the house is sold to pay for care home fees, this will dramatically change who receives what on that person's death. In such a situation, it may be possible to apply to the Court of Protection for a statutory will, which instead of leaving the house to certain people and the residuary estate to other people, cash amounts left, or the estate is split into percentages instead. Alternatively, it may be necessary to apply to the Court of Protection for a statutory will for inheritance tax reasons. It may be that if a will is drafted a certain way, it will be more tax efficient. For example, you may have heard recently about the relatively new resident nil rate ban. Now that applies where you have a property and you leave it to descendants. Your estate also has to be below a certain threshold, but I won't go into the details of that now. So as I say, it only applies to people who own their own residence and leave it to descendants. If you happen to make a will before the residence nil rate ban came into effect, you may have included a trust, or for other reasons you may not have structured your will in such a way that your house is left to your descendants. So you could lose out on that inheritance tax benefit. So it may be that it's quite clear that you just need a restructuring of your will, but if you lack capacity, then that will need to be a statutory will made through the Court of Protection. We're now going to talk about testamentary capacity. Testamentary capacity is a person's capacity to make a will. And obviously we need to know whether a person has capacity to make a will themselves or whether we need to apply for a statutory will. A person may not have testamentary capacity due to dementia or other illnesses or disabilities. The legal test for testamentary capacity was set out in the 1870 case of Banks and Goodfellow. Our team were recently involved in the case of Clitheroe and Bond, which confirmed that the Banks and Goodfellow test is still the correct test to apply after all these years, not the newer test in the Mental Capacity Act, which applies to other decisions like lasting powers of attorney. The test has 4 parts and says that a person making a will has testamentary capacity if, number 1, they understand the nature of the will and its effect. In other words, they must know what a will is and what a will does. Number 2, they must have some understanding of the extent of the property of which they are disposing under the will. So they don't need to know their exact bank balance or how much their house is worth to the penny, but they must have a good idea of how much they are leaving, what is in their estate. I think this includes having a fairly up-to-date idea of the value of money generally. I sometimes ask clients, would mum sell me their house tomorrow if I offered them £50 for it? And that seems to be quite a clear question, because, you know, if someone thinks, oh yeah, that'd be great to have £50, then you can see that they don't understand the current value of money and the value of their assets, which then casts doubt on whether they have testamentary capacity. The third part of the test is that they should be aware of the persons for whom they would usually be expected to provide. So, for example, how many children they have, if they have moral obligations to anyone in particular, whether anyone would be in financial difficulty if they didn't provide for them. And the fourth part of the test is that they should be free from any delusion of the mind that would affect their dispositions to those people. If someone is deluded and as a result of those delusions thinks badly enough of someone to write them out of their will, they may lack capacity. Sometimes the delusions might be obvious to the person making the will, to the solicitor writing the will, if they're outlandish, but sometimes they're actually quite difficult to spot. So often it is obvious if someone has the mental capacity to make a will or not, but sometimes we're asked to prepare a will for someone who perhaps has an early diagnosis of dementia, has told us that they've got some memory problems, or perhaps it's simply obvious to the solicitor writing the will that not everything they're telling us adds up. In that case, it is best practice to seek a mental capacity assessment by a doctor, and you may find that a solicitor is not willing to prepare the will without the mental capacity assessment. If the doctor says that a person does not have capacity, it will be necessary for an application to be made for a statutory will. As I say, it is often more obvious than that someone lacks capacity. We often act for clients who have suffered head injuries in accidents, particularly if they've received compensation, as having a large cash sum in their estate may not have been something they envisaged before the accident when deciding whether or not to make a will or what the terms of the will might be. Now, applying to the Court of Protection, I would like to say that the procedure for applying to the Court of Protection is straightforward, but in my experience, dealing with the Court of Protection is never particularly straightforward. It has always been the case, but particularly since COVID, they've had lots of staffing issues and their turnaround time is extremely slow. As such, if you are considering applying for a statutory will on behalf of someone, the sooner you make the application, the better. In the sad event of the person dying before the application has been dealt with, no will be in place. There is no halfway measure. I've set out on the slides the numbers of the forms that make up the application. It must include a witness statement with a family tree, a draft of the will you would like the court to approve, and written consent from the executors that they're happy to act. A mental capacity assessment in form COP3 must be completed by a medical professional, and supporting information about the person's assets and affairs must also be included. Once the application has been issued, notice must be given to various family members, including anyone who will be adversely affected by the will. For example, the beneficiary is under an old will. They will then have the opportunity to become parties to the application and for their interests to be considered by the court. In the example of John above, if his unmarried partner is making an application for a will to be made out in her favour, who does this mean is losing out? It may be his children or his parents, for example. They will need to be parties to the application and of course may object. You can't make the application without letting them know. It is not always the case though that they will object. For example, I dealt with an application where we simply wanted to remove the person's ex-daughter-in-law from their will. The ex-daughter-in-law agreed that it would not be appropriate for her to be in the will anymore and gave her consent to the application. It is likely that the official solicitor will be appointed to represent the person who lacks capacity in the proceedings. Their role is to ensure that the person's best interests are prioritised. There is likely to be at least one hearing for the court to consider the application. If the matter is very straightforward and everyone, including the official solicitor, agrees to the proposed will, it may be possible to avoid a hearing. Clearly, if the application for a statutory will is opposed, for example by relatives who are going to be left out, then there may be more than one hearing, and ultimately it will be for the Court of Protection to decide whether or not to make the will. If an order is made that the statutory will should be made, it will need to be signed by someone on behalf of the person who lacks capacity in the presence of two witnesses. It must then be sealed by the court. So how does the court decide? It's really quite tricky. The court's main concern in making a statutory will is the best interests of the person who lacks capacity. That in itself it is quite a complex and difficult one for the court to consider. The will, of course, is only ever going to come into effect when that person has died. And so it's hard sometimes to consider how a will can be in their best interests or affect their best interests at all, regardless of what it says. Well, the court will endeavour to take into account their past wishes and feelings. I had a case where a relatively young man had a brain injury, and he had made it clear to his family beforehand that he wouldn't want his children inheriting his estate at 18. That estate then became bigger as a result of the compensation payment that he received, and so it seemed even more clear that his children shouldn't inherit if he was to die before they turned 18. So we can see how those were his past feelings. The present wishes and feelings may also be possible to ascertain. So you may be in the position where a person is quite clear about what they want in their will, but isn't able to fulfil the Banks and Goodfellow test, and it just becomes necessary on balance to make the application to the Court of Protection. In that case, we may have some clear wishes and feelings. They'll also look at their beliefs and values. If you have somebody who lacks capacity, who favours certain charities, it may be fairly obvious that they would like them to benefit. I need to make it clear that capacity is not all or nothing. So past feelings, present feelings, and beliefs and values should be taken into account by the court. The court must also take into account other parties' views of what they think would be in the person's best interests. The court can also take into account, and should take into account, how the person will be remembered after their death. For example, as being generous or having done the right thing. Interestingly, the official solicitor, so just to recap, the official solicitor is usually appointed to represent the person who lacks capacity in the proceedings, and the official solicitor will talk to the person, see whether they can ascertain any wishes and feelings, look at the family tree and so on, and try and be the one person that represents them and has no other interests, as opposed to a family member who may benefit from the will. The official solicitor is likely to oppose an application for a statutory will if there are not enough liquid assets to pay their costs and the costs of the application as a whole. So this must be taken into account too. If there is only a house and no liquid assets to pay the costs of the application and the official solicitor's costs, they may oppose the making of a statutory will, which is a difficult one to work out the logic of, but that is the case. It has been a bit of a whistle-stop tour, but I hope it has provided some useful information on when a statutory will is required and how to apply for one. Before I take questions, we will be sending a recording round to everyone that signed up to today's webinar tomorrow morning. We'll also include a link to a very short feedback survey. We'd really appreciate it if you could complete it so that our future webinars are helpful to you. As I said at the start, this is one of a series of Wednesday webinars. Our next webinar is about trust registration on the 30th of November. If you're interested in our future webinars, please visit our website, birkettlong.co.uk/events, or our Eventbrite page to sign up. I'm happy to answer any questions.
Thank you, Kay. Yeah, we've got two questions. The first question is, my mum has been diagnosed with dementia. Does this mean she can't make a will?
No, is the short answer. So a diagnosis of dementia does not preclude your mum from doing anything. It's just a diagnosis. So mental capacity is now seen as time specific and decision specific. So people can have good days and bad days. People can also make some decisions and not others. So clearly your mum might be able to make some simple decisions and may find it more difficult to make some complex decisions. Now, whether or not she can make a will depend on the Banks and Goodfellow test that we set out before, and it may depend on how complex her estate is and how complex her family is, and what she's intending on doing in her will. However, what you might find is that the solicitor who you instructed, or who your mum instructs to prepare the will, wants to get a medical assessment, and if the doctor says that she lacks capacity, it's only then that you will need to look at possible application for a statutory will.
Lovely, thank you. And the second question is there an alternative to a statutory will if we all agree?
So that's a good question. Now, what you may have worked out from what I've talked about is how the Court of Protection are not particularly efficient, and it's a complex court application. You know, we have to get a doctor's report, we have to get a family tree. All these things take time, and then once you get to the Court of Protection, they take their time as well. Excuse me. So you may be looking at alternatives, or, you know, the sad fact is that some people will die during that process before a will has been made. So in terms of alternatives, if you all agree, it is possible to enter into a deed of variation after someone's death. So a deed of variation can be entered into by the beneficiaries under someone's will or their intestacy, and it changes the dispositions of their estate. So if the will is out of date and everyone agrees the will is out of date and certain things should be tweaked, that can be done within 2 years of someone's death under a deed of variation. Now, what I would say about that is children can't enter into a deed of variation. You all have to agree. And also you can't do it if it could be seen to be a deprivation of assets for care home fee purposes. So if you're trying to divert assets away from someone who may go into care with a view to the local authority paying for their care instead, you can't do that under a deed of variation. That won't be effective.
Thank you for that, Kay. I'll leave it with you to close the webinar.
Thank you. Well, thank you for joining us today. I'll review any other questions not answered and contact anyone we haven't had time to respond to. Have a good evening, everyone.